guys, it's Kathy. I hope you're doing well. Well, I just saw you a couple hours ago, but now it's Monday morning. Time to get to work, guys. You have work this week. Let's go. I had a new judge to show you today from Colorado, and I can't show you it because I have such good stuff instead. So that'll have to wait until tomorrow. Buckle up, guys. This is going to be a crazy stream.
Magistrate Court Superior Court bond hearing calendar. Today's date is January 16, 2026. This is the state of Georgia versus Luciano Jenkins, warrant number 2025 CW 57868. All parties are present and have announced ready to proceed. Attorney Tucker Williams.
Yes, this is our motion. This is our motion for a bond for Mr. Luciano Jenkins. Good morning, Your Honor. Good morning. I said it already, but let me just start with good morning. And we're glad to be here. Our position is that Mr. Luciano Jenkins is entitled to a bond. I believe that the court may know the charges, but if I briefly go over them, Your Honor, the charge, there actually is one count to my knowledge, and it is a criminal attempt to violate GCSA. When there's a claim that he was involved in some actions by another employee, I guess an independent contractor, Ms. Nashara Alaris, who did get a bond, Your Honor, I think approximately a month ago. So I wanted to say that. And she had 8 counts, not criminal attempt, but actually her charges were drug violations and cross guard and gun and alcohol, marijuana, all of that. His is a criminal attempt, and that is not what she was charged with. She was charged with actually being involved. And they are all charges. So Mr. Jenkins is 25 years old. He is a lifelong resident of Georgia. His entire family, his mother, who he would live with during the bond, and this is Shelley Delmar, and behind me, Your Honor, that's my paralegal, my criminal paralegal. I just want to identify for the court why these people are here. He is 25 years old. He is the father of a 5-year-old. He is we're going on, so keep it down. I'm sorry, Ms. Thomas?
That's the background in the jail. You can continue.
Yeah, okay, I'm sorry. If there's a problem, thank you, Your Honor. He is the father. He's a father, a son, and a brother. He's a graduate, which we don't always see in criminal cases. He's a graduate of Stockbridge High School of 2019. His brother, his mother, his father, his grandmother, who I know, they live in Georgia and as I said, he's a lifelong resident of Georgia. Now, if you want me to go through, and I will, there are standards of why he's entitled to a bond, OCGA 17-6-1. He does have one, I don't know how the court wants to characterize this, but there was a plea in Fulton County where he pled first offender. It has nothing to do with anything that alleges drugs or anything like this charge. And that is all that he has been convicted of, Your Honor. There were some charges at the jail. I don't really want to go into that. They are pending, but they have to do with, problems that are notarized and the fact that he was so young and he was in the jail. But that is not a conviction. There was another arrest, and that case, the jury found him not guilty on all counts. So that's his history. The court knows that you can consider his resources and assets, and he doesn't really have that right now, and that was because he was in the Clayton County Jail, Your Honor, for a significant period of time. The purpose of bail is to basically have him out working on his defense. And as I said, I'm not going to go into the facts of the case, though the state may want to go into that. But essentially, it's allegations and circumstantial evidence. We were representing him um, at the preliminary hearing, and there are a lot of problems with that case. There's no one that says he actually entered the jail or has said that he was there. That would be the co-defendant. We asked a reasonable bond, Your Honor, for Mr. Jenkins, and we believe that a reasonable bond would be commiserate. I'm sorry, and I thought I turned my phone off. Did you turn that down? Thank you. Um, it we are asking a reasonable bond of $5,000 and it not be cash. And we think under the circumstances that is very reasonable. I will be in this case throughout the tenure of the case, Your Honor. If the court wanted any special restrictions, which I don't believe were done in the case of the co-defendant, we are amenable to that as well, Your Honor, but we do want him to be able to work, to take care of his daughter. And we believe he meets the criteria. There is no reason that he would have to stay in jail because you're innocent until proven guilty. And in particular, in his case, he was charged with a very serious crime and spent 3 years in jail, which he was later exonerated. So we want to really look at things like this. There's no reason he should stay in jail. That's it. If the court has any questions, I'll be happy to answer.
Oh, the court has questions, but not yet.
All right, 88 Thomas.
Your Honor, this young man was actually in the jail. I had a previous case with him. At some point, he made bond. He
No,
established,
I'm sorry, and I apologize. I'll come back and deal with that. Excuse me. No, that's not correct. But I'm sorry. We'll go back and correct that.
Your Honor, if Ms. Williams has more to say in the presentation of her case, I'll wait.
I just thought that was a very important point. He did not make bail. He was exonerated of those charges. He spent 3 years in jail in Clayton County. Thank you. And I apologize. I won't interrupt again. I apologize.
Let me try again. He was out of jail. He had been released and was out on bond or out of jail. At some point, he established a relationship with the co-defendant who was an employee at the jail.
What year was that?
That was last year, Your Honor.
So
The initial
2025.
relationship,
No, not the relationship when he was released from custody. When was that?
that was last year, Your Honor, because I've actually had him on a previous case. So
Okay.
when it first popped up, I was like, where is he coming from? I'm like, okay, this is something new. Well, what the testimony at the hearing revealed was that he had established a relationship with the co-defendant, Ms. Nashara Laris. And through that relationship, which was established through text messages and what have you, and actually, if memory serves, her statement to the investigator at the time, he came up with a scheme for her to smuggle in various and sundry items into the jail. These items were found in her possession, but again, as a result of the investigation, they were able to determine that he actually was the person who pretty much had come up with it. In that regard, he had his brother actually deliver, I believe it was cell phones to Miss Laris, and she was to deliver them to designated people in the jail. She was paid for her services, and that was shown through Cash App deposits from him to her, which was all printed out, and there are copies of that in law enforcement custody. So if anybody, she ended up at this point in time with the bulk of the charges. I'm still not sure why, but he was the instigator of the transactions to begin with, and he did that through his relationship with her. So
Was he in custody or out of custody when this
at
was
the time he was out of custody, but he was using, because she actually worked in the jail, he was facilitating, he was making arrangements with the inmates in the jail, basically taking orders. She would be the one that would drop off whatever it is that was ordered, and then she would get part of the proceeds. They would pay him and he would pay her. So that's what was going on with this. And when the sheriff's department found out what was going on from her end, is when they were able to establish, okay, this is what's going on. This is a person who's on the outside, who's facilitating all this, who's getting payments from inmates in the jail, and then forwarding the co-defendant share to her. And
Your Honor,
at one
may I enter an objection? We're not
Your
trying
Honor,
to
may I
case.
please finish this time and then she can.
I just
She
want to
has
form
an
an
objection.
objection.
What's
I
your objection?
form the objection, Your Honor, that we are not doing a preliminary hearing here. If she's going to do all of this, he is innocent, and she is going into as though this is a preliminary hearing. We're here to see if he is a flight risk, is he a bond risk. The facts that the state is, and we are sending them to the court. If I can have that on an email, Your Honor, they are incorrect. And I just ask that we talk about, we know his charge. If she could talk about that, not saying hearsay, all of that, that he's guilty and he did this and that. Because then that makes me have to have an argument, because I did argue this case in a preliminary hearing and I represented him and tried the case that went to trial. And it's unfair. It's not why we're
Okay,
here
so
today.
Ms. Tucker Williams, and part of one of the prongs is determining whether he has the capacity to commit this in the future and to protect the community. So knowing that, I have to know some factual information about the allegations in order to make that determination. So your objection is overruled. Ms. Thomas, you can finish.
Thank you, Your Honor. So at this point, Your Honor,
Hi, Lisi.
state would contend that he is a risk to the public. The fact that he was able to get out of jail for however means, I'm not getting into that. That's not a part of this case. My concern is that he used those connections that he made when he was in jail to establish this scheme and was smuggling items into the jail. Your Honor, from my recollection of the facts of the case, I don't think any weapons were actually smuggled into the jail, but I do know it was various items of contraband. And those items were found in Miss Laris's possession. So at this point, Your Honor, state will be asked. State has no recommendation for bond whatsoever for this young man, and would ask the court to consider that in its evaluation of whether or not bond would be appropriate. I do believe that he is a danger to the community. I do believe he's definitely a danger to the people, the community in the jail, because no telling what he was trying to get into the jail. And I would ask that the court keep that in mind when it's in its evaluation of whether or not whether or not he should be entrusted with a bond again.
Your Honor, may I please?
Your Honor, state has concluded this
correct the
argument, Ms.
record when
Williams.
she's
I
finished?
will give the floor to Ms. Williams.
Yeah, and I'm sorry, I'm really passionate in this case because I did represent him, and it's important that the court knows the facts. Your Honor, may we have your email address and Ms. Thomas's, may we have yours? Because we do have evidence, not just what we're saying, but we have proof that the things that were said are incorrect, and we want to correct the record.
So it may not be relevant to what I have to what I'm looking for. So what was incorrect that you want to bring up to the court?
Okay, so Your Honor, there was a jury verdict on not guilty, and she's talking about she's aware of the case, October 27th, 2025. My client was at the
Your
jail.
Honor, I'm going to object at this point. I believe my point was I don't know anything about the case. I don't know what's going on in October, and I did not mention that as a part of my presentation. My presentation solely had to do with the facts of this particular case and why the state feels that this young man is a danger to the community.
I know this is a passionate case, but I have to make the record is correct for the court, because the court's going to make a determination on things that were asserted to it, and we need to have.
Yeah, so you've actually told the court 3 times that your client was found not guilty. I got it. I heard you.
When I said that, Your Honor, is because she said he was out on bond and he committed the crime
I
on.
heard you. I heard you 3 times, Miss Tucker Williams, that he was acquitted of his charges.
But not just that, Your Honor, he wasn't on bond, because we do have proof that he was released from the jail in November. And the reason I know it was November is because it was his birthday. If the court would look up a little, that's not what I'm not trying to go into the verdict. I'm going into the fact that he was released, because that is a serious allegation. And while he was out on bond,
Is he still on probation?
He didn't ever get to start, Your Honor. He was only out a few days. Yes, he's on probation, but only in Fulton. And I don't even think they revoked him. He didn't even get to start probation. He was released, Your Honor. So all these allegations that he did all
wait,
this.
hold on. So wait, let me make sure I understand it. So he was sentenced in, I think it looks here, September 2025 in Fulton County for aggravated assault, and he's on probation for that currently, correct? Because it
Yes,
Well,
ma'am.
indicates in
yes,
that from my
Yana, may
but
I
I'm listening.
answer?
Hold on, wait, no, stop.
Okay.
All right, I'm looking at his GCIC. It indicates that he was sentenced on September the 5th, 2025 in Fulton County for aggravated assault and placed on probation. Ms. Tucker Williams, is that also your understanding?
Yes, Your Honor, but may I speak, please? And the reason
No,
I can
no,
speak,
not right
I
now. No,
represented him in that case, Your Honor.
Ms. Tucker Williams, if I don't have a fundamental understanding, you talking about what you think that I need to hear is not going to help you. It's
All
not
right,
going to
Your
help
Honor.
me client.
Yes, Your Honor. I was the attorney in that case, and he was
I've heard you say that 3 times.
no
You
only in
repeating
Fulton.
Miss Tucker Williams. You have told me 3 different times that you've represented him. That's his grandmother's your friend. I've heard you. I am listening clearly. I heard you.
I
So
know.
is your client on probation for aggravated assault?
Yes, Your Honor, but he was in custody in Clayton when that plea was entered, and so he never officially got to even report to anyone in probation.
Okay.
And that's all I was saying, not to tell you that I represented him in Clayton, but I represented him in Fulton, and that's why I
Yeah,
know.
I didn't even need that information. I was just trying to be clear if he is currently on probation
I
for
don't think
aggravated assault.
yes, but nothing to do with these allegations. And no, Your Honor, he was. I don't think he actually ever visited with his probation officer. Is my understanding.
Yeah, so that's not even he took a plea and he pled guilty to aggravated assault on September the 5th, 2025 in Fulton County. Is that correct?
I believe it was an Alfred plea, yes,
Your Honor, that's what I show on the criminal history also.
and it was first offender.
That first offender
He
has
had
not been
no,
sealed, however.
he had no prior record. That was a domestic case. Yes, Your Honor. And it's,
Actually, he does have a prior history, a prior arrest, Your Honor.
where's the prior
Yeah.
conviction?
He had I didn't say a conviction. You said he had no prior history.
No,
He
I said he
does
has
have
no
prior
prior
history.
conviction.
No, he has a first offender, I see, from 2022. He did pretrial diversion. And what year is this? 2019. So your client has been in and out, ma'am. So I'm
I didn't
looking
even
at this.
know about
I'm
that.
looking, yeah, I know. And I know
What-
they don't always tell you everything. So,
I,
but I'm looking at his GCIC. He did pretrial diversion in Henry County in 2019. He did first offender was his 2022 for aggravated assault.
no, that's the case, Your Honor. That's the case in Fulton. He couldn't have qualified for first offender if he had a prior felony.
It
We let
happens.
him in. I'm sorry, Ms. Thomas.
It happens.
But
I'm
Your
Well,
Honor,
looking at the
I'm,
same
I'm
thing the
looking.
judge is looking
Yeah,
at.
we're looking at his GCIC. He
please
had
look
a
at it,
first.
Your Honor.
He has a first offender that was deferred on September the 5th. I guess that's this case that he's on probation for.
Yes, Your
The
Honor.
sentence says 2 years probation, so it's a first offender aggravated assault.
Thank you, Your Honor. That's correct, Your Honor.
Yeah, I know. You don't want to keep correcting everybody when we're looking at his actual criminal history. We're not guessing. I'm not grabbing
But
this out the air.
the state was saying it was a prior conviction, and I was just saying that's
That's not what I said.
No, and he has an arrest in 2023 for aggravated battery.
it's that case, I believe, Your Honor, out of Fulton. That was the arrest.
No, that's a Clayton County charge.
Yep.
No conviction. There's no disposition that we've seen. He
Yeah,
was
but you
qualified.
maintain that the client didn't have any criminal history, and he has how many 7 cycles.
Where are they, Your Honor? Let's go through them. Those cycles are out of the jail where he was attacked. And I don't even want to get into what happens to these young men that look like him, that are young and handsome when they go to jail. And we know the history at Clayton County. But
All
what
right,
we're looking for is his convictions, Your Honor, and is he likely to commit a crime? And there is nothing, that case out of Fulton, I'm not going to go into all that. I was his attorney, and I know that that was a plea, and it was an Alfred plea. But the real facts are the co-defendant got a bond with 8 counts. His is an attempt, Your Honor. There's nothing that says he was ever convicted or arrested for possession of drugs. And that's what we're looking at. And the court, I know the court wasn't involved with the first case when we went for the preliminary hearing. It's all circumstantial. Like for the state to say he did all this, really, those things are there. It's important that the record is correct. I don't want the court to think.
So what's incorrect? Well, I just went through his GCIC. So what did I say? I went by his GCIC. So what did the court say that was incorrect?
No,
Tell me.
Your Honor, if I may,
Yes,
I'm
tell
not
me.
fighting with the court, Your Honor. I'm here to get
No,
us
you said you're now. I'm
the
literally
state.
reading his GCI. I'm not talking about that. I'm going by the GCIC. What did I say? The court say that was incorrect.
The court, I will look at it. To my knowledge, Your Honor, the case out of Fulton, which may have been charged as aggravated battery and it ended up being assault, is the same case.
Okay,
It is the
I see
same
that.
case. It is not
He had
like
a lot of charges. One of which I didn't want to say online in public. He had one that was a lot worse than that, and I gave him grace by not calling it out loud. Do
and
you
it's
want me to say it out loud?
put it on the record, Your Honor. I
Murder.
represent.
He was charged with murder. Did you know that?
Yes. Did I know, Your
Okay.
Honor? I was trying to tell the court I was his lawyer.
That's what I keep telling you. I have the GCIC. So what all you're saying, I'm looking at it.
May I speak, Your Honor? This is what is correct. I will tell the court what is correct in my point of view, and I was his lawyer, if I may. And it's like it's easy.
I know, no, I already know. He is on probation that you have said multiple times that he hasn't had an opportunity to report to because he's been in custody. He is on 2 years probation for aggravated assault out of Fulton County, and the date was September the 5th. I don't need you to rehash that a million times. I got it.
Oh,
I
I
am
wasn't going
1000%.
back. Oh, and now we're correct. That is correct, Your Honor. But the thing
I
saying
know that. That's what I said in the beginning, that he's on
right.
probation for aggravated assault.
Well, may I go further, Your Honor? The big
Okay, what
contention
is it?
was that he was out on bond. This is his second. That's not correct.
I just said I'm clear about that. How many times
Right.
can I say that?
I just want to, because there were two different contentions. Your Honor,
And I just said I reviewed it. That I
Mhm.
understand he was just sentenced and he hasn't even had the opportunity to report. And
Right.
you went back and revisited the same point that I just said I'm clear
Right.
about.
And can we get his release date from Clayton, Your Honor, please? Because the court was interested in that. Can we correct the record on that?
No, I wasn't interested in it.
Your Honor, we're here for a bond. I mean, all of this is not even the standard. I had to correct the record as the
No,
things
the
that were
standard is
incorrect.
no. That's actually is the standard because I have to see what his propensity. If I give him a bond and he's on probation for aggravated assault is a violent crime. That's exactly what we have to consider
That
when I
is
consider setting a bond.
one first offender, Your Honor, and he was the only reason it was a Alfred plea. The only reason he took it because he was in jail in Clayton and wanted to go on and resolve that. That was involving his girlfriend. I won't go if we're gonna go into the facts. I don't think the court wants me to do that. But as we stand now, it is a first offender, which shows he doesn't have this propensity. He wasn't in jail prior. He wasn't arrested. This is the case. And we're here today on one other thing, and not arrest. That is not arrest. If particularly if he was found not guilty, I'm happy to say he was charged with murder, and the jury within less than an hour came back on 8 counts of not guilty. I'm happy to say that I was his lawyer. And if
We're
we're gonna
talking
go
about
by
the.
people
I don't know why you
accusing
keep
people,
rehashing this. We're talking about the aggravated assault in which he's on probation for.
that is
And
it. And
I'm sorry. Let me
they
make sure. Hold on. Let me make sure I'm clear. So the aggravated assault on which he's on probation for, that comes out of the same factual scenario in which he got the acquittal on the other charges, or
no,
is that a separate case?
that's separate.
So this okay. So that's another cycle. All right, another cycle of a violent arrest.
But you
All
call
right.
it
Anything else?
another cycle, then he was found not guilty, Your Honor. He's gonna
Yeah,
be accused of
now
being a
he's on
criminal.
probation for aggravated assault.
But that was 3, 4 years ago.
No, that was 2025.
Well, that case was not.
Aggravated assault is September 2025.
That was the day of the plea, Your Honor. But I believe it was right before he was in jail in Clayton for 3 years.
Anything else, Ms. Tucker Williams?
Your Honor, what was the amount of his co-defendant's bond? She was charged with not attempt, he was charged with attempt.
Are you asking the court that question?
I would like to know.
She's not on the bond calendar, so I don't have her.
No, I'm sorry. No, that's correct, Your Honor. Let me advise the court. She got a bond immediately after she was arrested.
Now, this is like the 5th time you said that. I'm clear about that.
Right. Okay.
She also wasn't on probation for aggravated assault.
Do we know that?
Yeah, we do, because she was an employee at the jail. You can't be an employee at the jail on probation for aggravated assault. That's just factually implausible.
Well, Your Honor, she was an independent contractor at the jail.
It doesn't matter. You can't work at the. You know what, Ms. Tucker Williams? Okay? Keep going.
No,
Just keep going.
I mean, my thing is that this is. I came here to request a bond. Obviously, this case is very. Something else is going on. Whatever. I just came to say that he is entitled to a bond. And the court
felony. No, so that's the incorrect statement of the law. Felony charges are not entitled to a bond. The only charges that are entitled to a bond are misdemeanors. You keep saying that, and that's actually incorrect factually. The law, you have to give a misdemeanor person a bond unless they're on probation. Felony charges are not entitled to a bond, not in the state of Georgia.
But okay, on the motion for bond, my understanding is he would have to go before the court to get a bond on some felony, but not that just because he's charged with a felony, he's presumed innocent, Your Honor.
So every person that's charged with crimes until they're convicted is presumed innocent. Every person that's charged with a felony is not entitled to a bond. So I don't know what statement of the law that you're citing, but that's actually incorrect. Misdemeanor charges are entitled to a bond.
Well, let me say he would need to come before the court to get a bond if it was a prior felony. That's all I'm saying. I didn't come to argue with the court.
I can't tell.
Well, I didn't.
Okay.
But Your Honor, when someone who doesn't know the case, who hadn't looked at the case and states that he had a prior bond, I think I'm entitled to correct the record. Because the court's going to make a decision based on.
Nobody ever said he had a bond on this charge. That's why he's on the case.
And we can review the record that was said today.
Never had a bond set because it was denied because he was on probation when he appeared for this charge. I have the bond paperwork in front of me. So when he came to first appearance for this charge in Clayton County, his bond was denied because he was on probation in Fulton County.
I think they wanted to. I wasn't involved in that, Your Honor. I cannot speak on that, but my understanding is they wanted. Fulton has not revoked him. They are well aware of the charge.
No one said he's been revoked.
Correct. And
you keep talking to that point. Nobody's ever said that.
Right. And Your Honor, I just think that bears weight for the court to consider. They certainly know he is in jail in Clayton, and we go through the standard. Let's go through the first standard, Your Honor.
No.
He turned himself in, Your Honor.
So we've already went through all of these things, Ms. Tucker Williams.
I don't think I said he turned himself in, Your Honor. So
all right. Do you have any other new information that you want to tell the court?
I think the court has already made its decision before we appeal before the court.
Actually, I haven't.
You know,
and I take actually offense to that comment. The court had made up their mind. That's the point of the hearing. If I made up my mind, I would have shut this hearing down 30 minutes ago.
Well, all I'll say is, Your Honor, thank you for allowing us to be here. We certainly, the state and I see the case very seriously, very differently. Did you have a question, Mr. Jenkins? Did you have a question, Luciano?
Yes, I do have a question. I am out on bond in Fulton County.
Your Honor, if I may, before he starts, if Mr. Luciano Jenkins is going to be making a statement, first thing the state would ask that he be sworn in. Second, the state would ask that Ms. Williams and her client talk separately to be sure he understands what can happen if he starts talking.
We're not going to talk about the charges, but I would like to talk to him. Please, Your Honor, if he has a question, I need to talk to him.
Well, can they have a breakout room, Your Honor, please? I'm just trying to protect his interest because right now that doesn't. Ms. Williams, do you
My
need to
question
talk to
was,
her?
my first question was, did he have a question? And if he has a question, I would like to talk to him.
Did you have a question? Your attorney's asking.
Yes or no? That's all I want you to say, Mr. Jenkins. Yes or no, and we'll talk privately.
Yeah, no. But I'll talk to my attorney first.
Thank you.
All right, court will be in recess.
Thank you, Your Honor.
All right, court is back in session. All parties are present. I have any remaining arguments for bond made. Anything on behalf of the state?
Yes, Shauna. Actually, a question. I was looking at the Mr. Jenkins' history on CPU 8, and I'm seeing something that I wanted to ask the court about. It appears that this the co-defendant's case, as Ms. Williams has mentioned numerous times, has been assigned to a superior court judge. And I think this one actually has been too. And if I'm correct, I'm not sure we can set a bond. When you click on the charge, it won't let me even go into it.
Okay, Yate, would you check, please?
Okay, so
We're checking to see if it's been indicted yet. 'Cause if it's been
No,
indicted,
it hasn't been indicted. It's just been assigned with certain cases. If they involve when they like law enforcement or something like that, they have a special designation and they can only be addressed by a sitting superior court judge.
well,
Hers
we sit by special designation, so we have an order to cover that.
Yes, ma'am. But this is a little different because it actually they are assigned. They get like a superior court number and
I
everything.
see what you're
And
saying.
and I think this one may be like hers because that's why when her case came up, we couldn't hear it because they had already pulled it. So
Okay.
I don't know if we can.
I'm checking now.
All right, let me know when you find out, Yate.
Okay.
Your Honor, yeah, we would like clarity on that because we would probably
Ms.
have.
Tucker Williams, we just said we're checking.
I know,
You
Your
just
Honor.
repeating what everybody just said.
No,
We
Your
are checking.
Honor. No, Your Honor. I was saying we have no objection. Your Honor, give me a chance.
It don't matter.
She shut the stream off at that point. There's no more stream. Oh my gosh. That attorney was, oh my gosh. That magistrate handled it so well. I loved her. I loved her the whole time. She's smart. She does hear, she does listen. All right. Next, guys, I'm going to do something just so rare for my channel. So back in 2020, 2021, Lenise Bryant often streamed her court. Okay? But then some stupid YouTuber, put devil horns on her and on one of their thumbs. And she really, she is a God-fearing woman. And that pushed her right over the edge. So she wanted to, get the content creators and everything like that. And then she stopped streaming for a while. And if she streamed, she would only leave them up for a little bit. All right? Well, she had said that back then that she did not want content creators to get her. It's a courtroom. She did not. So that's why you never see Lenise Bryant on my channel, because she said she didn't want anybody to get her court. Fine, no problem. Well, recently she has started streaming again and leaving her streams up like normal, for a while. So I think she's gotten past that everything that happened with the devil horns and everything. Though I still don't show her much, I am going to show her today. I am going to show her right now. Because if you don't watch her, Judge Bryant, she is GOAT. Oh my God, she's so good. Now, unfortunately, yesterday, from from this day. This day was just like 3 days ago, I think, 4 days ago. Unfortunately, I don't have the day before this. You'll see why that's unfortunate, but this is better. This is way better than what would have happened the day before. I think the day before there was a passing comment at the very end of a hearing for one of the ladies. She made a comment when the case was over and she was about to shut her Zoom. And this comment sent Lanice Bryant over the edge. Get ready. Guys, this is so good.
And we're back, we're on the record with case 446000901 people state of Michigan versus Alexis Williams Green. This is of course a recall. And Ms. Easy over here.
Janice Stevenson, appearing on behalf of Alexis Green. Ms. Green, say your first name on Alexis.
Juanita Green. All right. Okay, even like up until this very moment, I hadn't made up my mind, but, I know that, Ms. Green, I know that I've said like a lot of times, how my mom was smart. I don't even know if I said this to you yesterday. I think I said it to somebody. I don't know. And I was saying, but I know that was I think that was the other person that was getting smart with me and stuff. That was sounding coming person. I don't know. But I said, yeah, because Miss Green, she left. She cursed and left. So that couldn't have been her. It had to be somebody else. Maybe it was the sentencing or something that I did yesterday. And I was saying, and I gave the story about my friend who got locked up for them 10 days for that bad attitude. So that wasn't Miss Green. And I'm just kind of like tired of coming to work and people cursing me. I am. I'm tired of coming to work, presiding over the cases that I have had no role in. I don't work for the police department. I didn't write the warrant. I didn't sign the warrant. I didn't decide to do the warrant. Then I show up for work, require that people do what they're supposed to do, like right now. Like right as we're doing this case right now, I'm having no problem with you, with your attention. You're not looking to the left. You're not looking to the right. You're not listening. The kids in the hallway not doing nothing. We're not trying to change the baby diaper. None of those things happen when we come in person. And the problem with Zoom is that you all get comfortable and think we're not in court. And then I don't remember if Miss Green was the one that was like, I'm looking at you. Because it was two of them that went off on me yesterday. And so I'm getting them, might be getting this, but I remember one of them was like, I'm looking at you. And I'm like, no, you're not. If I could play the tape back, I could show that you were looking just over there. And something else is getting your attention. But the funny thing about that is this. The only reason I care is because it's important for you to hear and know what is going on in your case. Because then you'll be the main one say, I didn't know I was supposed to do that. Oh, I didn't even hear the court date. Oh, I didn't know I was supposed to come. I thought it was at 10:30. I know it wasn't because I don't set stuff at 10:30. You paying attention is for your own good. If I was not a garder, Guarder, of constitutional rights and trying to make sure that people know what they're supposed to do, are in the place that they're supposed to be in, I would care less if you looking on. I would probably be maybe like some of my colleagues, and I don't mean them no disrespect. They could run their courtroom however they want to run their courtroom. But that's why people don't know what's going on. That's why people come back and say, well, I didn't hear you say that. Well, because at the time you was looking at whatever was going in the hallway. But what I didn't sign up for, because I went to law school, I went to college, went to law school, did some internships and stuff, went to new judges school. Now, none of those had to do a class on when the people curse at you. that happened to me. Nobody did a class on, and oh, by the way, the people gonna curse at you. Now, if I just come out the gate cursing, because we did used to have a judge that would curse at you way back in the day, way back. And he would just curse at you. That's some stupid ass. That's what the judge used to say. Now, if I had said that's some ignorant ass that you keep sitting there looking around and not paying attention, I would lose my job. And so I don't know today if you apologize.
Judge, you wouldn't lose your job. You let those swear words go, lady. You do it. You wouldn't lose your job.
To me, because you figured out or knew, because you didn't have to figure it out, we put you in the back. Because now you're going to jail. I don't know if you, because you sure weren't interested in apologizing to me yesterday, and you're like, I come in person. That's so rude and disrespectful. I did nothing to you except say, ma'am, I need you to be stationary. Ma'am, I need you to stop looking around. Miss Stevenson, I'm not going to be able to do the case if her attention is somewhere else. Now, I could be a person to care less about where your attention is when I'm doing your case that is determining of whether or not you're going to be on probation or go to jail. And if I could recall correctly, you doing a poor job. But let me pull it up. So I'm gonna let the county van go because they had the county on their way. That's why I had to stop my jury trial, because the county was on their way. So I'm gonna rescind the 3 days. I'll make it 1 day because she's been in lockup all day. But if you come on here and curse at me again, tell Ms. Greer, call Ms. Greer and tell her I said, thank you, but no thank you. They're going to come to me.
Oakley.
I'm not getting on their room. Okay. Tell her no thank you, but no thank you. They're gonna come to me.
And O'Donnell.
For me. All right. So let me pull this up to see. Even, because I said I was gonna put her in jail for 3 days and then look at the review. So let's see. All right, so she's on a 15-month probation. This is the first, I think that was the first review. No, I put her on probation in July. Let me see. And just so the record is clear, in case there needs to be some clarity, the contempt of court stands. I held her in contempt of court. I'm changing it from 3 days to 1 day, and I'm giving her the credit for the time she has spent in the 36 different courts locked up. All right, and so I put her on probation for 15 months in July. And then her first review was in November. 4 months. And so now this probably would have been a halfway point. And she's pretty much done nothing. She did the victims impact panel and the consequences video. And she still owes the full amount. She still needs to do the alcohol highway safety. She still has to do choices, and she still has to do marijuana insight. Now, the thing of it is, she has plenty of time to do it. So I'm unclear why she had that attitude yesterday. Chambers, this chambers, or we, I mean, if we're gonna be on Zoom, we're gonna be on my Zoom, but
Thank you,
they
Monica.
can come to
Thank you. Thank
chambers.
you.
So I'm not even sure why she had the attitude yesterday and cursed me at the end and gonna say, I ain't gonna repeat it again. I ain't gonna repeat it. Ms. Stevenson?
Your Honor, if I recall correctly, the whole hearing started to spiral out of control. The court did ask Ms. Green to be still. She responded that she was at work and there was some back.
Oh, because then I said I didn't care.
Right.
Didn't I say I didn't care that she chose to go to work on the day that she was supposed to come to court? And then that's when everything went south, because she probably thought I should care and wanted me to care, and I still don't care. Because when we have court, we have to take off work to go to court. Just like today, when the people have court, going to court on Zoom is not a right. Coming to court on Zoom is not a constitutional right. You only have a right to come in person. The only right to be in court is in person. Coming to court on Zoom is a courtesy to those who know how to come to court on Zoom, not to those who go to work and think I'm gonna work around them going to work. But the funny thing is, in general, I work around people who go to work, but I'm not gonna compete with you at work. So if you go to work and now it's time for your court hearing, it's your responsibility to have somewhere private to go at work so that the judge is not interrupted. Cause I ain't gonna compete with your supervisor, the students, the assembly line, the cars moving behind. I'm not gonna do any of that, cause I don't have to. So I'm sorry, I think I interrupted you. Go ahead.
No, completely agreed. And I think that Ms. Green sees that now, that the question that she did pose to the court, which, she had no business posing to the court. And I think she sees that now, was how is she supposed to take care of her costs and fines if she doesn't work?
Oh, yeah, she did. And I said I ain't care about that because we don't never have to even do cost and fines, because cost and fines is easy too.
And she sees that actually now her whole entire job is in jeopardy if she's not, she has to go to jail. So I think that Ms. Green has had the opportunity to sit and reflect over these last 5+ hours as to how much she really has to lose by not adjusting herself to the court, rather than requesting that the court, expecting that the court adjust itself to her. And I think we're gonna have some different experiences going forward.
Well, I hope so, because I never put the people's life in danger drinking and driving. That has never been my story on a date, but it was yours. It was yours. And so what we're gonna do is show up as if we're convicted of drunk driving. We're gonna show up as if it is our responsibility to handle our probation. Because let me tell you something, there's nowhere in my order. You're never gonna see it in my order where it said obtain and maintain employment. I can probably count on maybe 2 hands, because I've been on the bench for 18 years. So maybe on 2 hands, can count how many times I've told somebody to get a job or keep a job. Because I don't care about your job. You should care about your job before you get convicted of a crime. I don't care about your job. So however you gonna pay your fines, costs, and fees, you could take bottles back to the store if you want to. I had accumulated so many little bottles one time, cans. I went to the store, I was over the limit. Cause I just kept on not taking them back. Then I said, this looks ridiculous. This looks ridiculous. Let me take them back. Then I was over the limit. So it doesn't concern me how you pay your fines, costs, and fees. And had you talked to your lawyer might have told you, and the money is the least thing that this judge cares about. The money is the least thing this judge cares about. I'm not a collection agent for the court. I know it takes money to run a court. I don't impose fines, costs, and fees to pay for the court. I don't. If you can't pay, I'll waive them. I don't care about that. But if you come in here and curse at me again, you probably gonna lose that job. Unless they're gonna hold it for you. until you get out of jail. Cause you might be a great worker. If Mr. Flanagan go to jail, and the day he get out, I'm gonna ask him, can he come to work? That's how great he is. They're gonna be like, you know, Mr. Flanagan getting out today. Oh, y'all think he wanna come to work today, or he wanna go home and rest? That's my position. So I don't know how great of a worker you are, but you curse at me again, and we gonna find out. Is this the halfway point? Did I get to file that, or I just? Oh, and I'm sorry, let me correct my language. She didn't curse at me. She cursed about me when she was leaving the Zoom. That's what happened with her. She cursed about me, called me some name while she's leaving out. So when did I put her on? I put her on in July.
July 1st.
So July, August, September, October, November, December, January, February. Oh, this is January. Oh, why did I have to count 6 months? I didn't know that's a shame. That's a shame. So Ms. Stevenson, the halfway point would be 7.5 months. So she hasn't done most of the stuff though. So how much time do we want? I mean, since she's not at the halfway point, I won't make you go to the end. I can give her a different date in there, but
I mean, can we just get to the halfway point?
I don't want no extra. I don't want her to get another chance to curse at me. I don't want to give her no extra chance to curse at me. If she's not going to be finished by the halfway point, I don't want to see her.
July.
No, the halfway point, I put her on in July. So when is the halfway point? Because July that would be 12 months. No, 15 is 7.5. We're at 6 though. That's February. That's like the beginning of March. Let's maybe bring her back in April or May, but because I don't want to give her no extra chance to curse me because she's going to jail. She cursed me again, she's going to jail.
It's not gonna happen.
Okay, so what day you want? What day?
April 14th. We'll make two.
Oh, no, I'm gonna be in, I think I'm gonna be in, it's 2 on that day?
Yes.
Oh, no, I think I'm gonna be in Memphis. I am. I'm gonna be in Memphis, so we gotta move those two. Oh, and it's one on April 15th too. I'm gonna be in Memphis. So we could probably do April, like April 20th.
April 20th. So
Oh, that's weed day. I said I wanted to put nothing else on weed day at 4/20. I said I was gonna boycott weed day.
That's weed day.
Oh, that's what they want me to do. Oh, you're right. Thank you. You are right. So I should clog up the docket that day. Everybody come in and test. Okay, so we're gonna continue your client to April the 20th, which is a little bit past the halfway point. And that's at 10 o'clock. And she can do whatever she wants to do, in terms of her job, but I'm not competing with anybody's work. And and the grace that I'm giving is that I'm not even requiring her to come in person. You know, she cursed me. I'm not requiring her to come in person, even though she wasn't looking, even though she wanted me to compete with her job, even though she wanted me to care about her job. I'm not gonna require her to come in person, but if she is not properly attending Zoom, she gonna have to leave her job and come to work, and come to court that day. So I don't know how that's gonna work out, but. Anything further, Ms. Dixon?
Nothing at this time. Thank you very much, Sharon.
All right, then we're all set. Have a great day and stay safe.
I love that judge. I really do. Okay. Okay. All right, wait, I'm not going to do that one yet. I'm going to do this one first. This is real short, guys.
All right, Mr. Flores, I'm gonna send you a link for next week, same time, same station. Let's see if we can get you back in diversion, okay?
All right.
All right, so here's your option. You wanna take a plea, we can close it out. If you don't wanna take a plea, worry about it being on your, it's a plea to a disorderly. Either that, or if you get back in diversion, you gotta jump through the hoops or whatever diversion wants you to do. Your call. But you think about it, I'll see you next week. You tell me then whether you wanna take a plea and be done, or you wanna get back into diversion, okay?
All right. So if I take a plea and be done, would it be on my record?
Yeah, it'll be on your record. It'll be on your record as a plea to a disorderly conduct. No, not any worse than your obstruction, sir.
And what exactly is a disorderly conduct? Like, is that like severe? How severe is that?
It's a bailout. It's not a crime of violence per se.
Well, I'll do that.
Yeah, of course you will do that. Come on, man, what are you doing jerking me around? Don't fucking be playing bullshit. All right, raise your right hand. Stand still and raise your right hand. Do you swear or affirm to tell the truth?
Yes, sir.
All right, you may put your hand down. You're charged with one kind of disorderly conduct. Do you understand that charge?
Yes, sir. I do.
How do you plead? Guilty or not guilty?
That's guilty.
You understand you give up certain rights that you have if you plead guilty?
Yes, sir.
Hold on, I'm gonna put them up on a computer screen for you. All right, there's a document in front of you that says record of defendant prior to entering a plea. Okay, you have a right, if you plead guilty, you give up the right to a speedy and public trial by jury, the right to have the state prove the case against you beyond a reasonable doubt, to be presumed innocent, to confront witnesses against you, the right to subpoena witness, to testify and offer evidence, right to assistance of counsel during the trial, and right not to incriminate yourself. You understand these rights you will give up by pleading today?
Yes, sir. I do.
May I sign your name to this plea sheet to show that I told you what these rights are?
Yes, sir.
And you do not wish to have a lawyer represent you?
Yes, sir.
Okay. You don't want a lawyer, right? You're gonna handle this yourself.
I mean,
You want to talk to a lawyer first before you plead?
no, sir. No, sir.
You're good?
Yes, sir.
All right. I'll find waiver to be knowing and voluntary. Credit how many days, Mr. Kim?
Credit 2 days, Your Honor.
And close?
Yes, Your Honor.
All right. Sentence of the court will be credited 2 days and close the case.
Wait. So.
All right, Mr. Flores, go and sin no more.
All right. So does that mean the case is closed?
Yeah, you're done.
All right. Thank you.
Yeah, jumper, yeah. Get out of here.
Thank you, boss.
Oh, my mic is on. Okay. Last night we met a judge from Colorado that I really liked. I have another small clip of her before we get to the last clip. Can't remember her name, but it's on the screen. It will be on the screen in a second, actually. There we go.
Ryan Hall for the people.
Castle for Ms. Pinkham on behalf of Mr. Knoll. Judge, the court needs to advise Mr. Knoll of the protection order. At this time, he is not willing to sign it. I think that does relate to the reason that case is going to 1H. That being said, the statute does not require that he sign it. It's not a case involving unlawful sexual contact, stalking, or domestic violence. And so as long as the court advises him on the record, that is sufficient.
Okay, Mr. Knoll, why won't you sign the protection order?
I have never committed a crime in Colorado.
Okay,
There's no one to protect.
okay. At this time, the court on its own motion is going to raise the issue of competency. Mr. Knoll, I'm going to set your next hearing in courtroom 1H. Well, they can make a determination as to whether or not you're competent to proceed. The court will stay or enter the mental health stay in this matter. Mr. Knoll, I understand that you do not want to sign the protection order. However, I will advise you that you shall refrain from contacting directly or indirectly communicating with any victims or witnesses. You shall not possess, purchase, or control a firearm or any other weapon. You cannot have any ammunition. You can't consume any alcoholic beverages. You can't take, transfer, or I don't know why box 8 is checked. I don't necessarily think that's applicable here. And I will indicate on the record that I have advised you as to the protection order boxes 3, 4, and 5, and 7. I'm going to direct the people to uncheck box number 8 based on the charges that Mr. Knoll faces. I don't think box 8's appropriate.
Understood.
If you can give me a new copy, I will sign it and include it as part of the record indicating that I've advised Mr. Knoll. And then Mr. Knoll, you're going to go to courtroom 1H on what date? January 20th at 1:30. You're going to go downstairs. Mr. Castle's going to write that down for you.
May I speak? I've never had a victim in Colorado.
Okay. I understand. Some of it didn't make sense, so that's why I changed it. But you're going to have to address these larger issues of your competency with Judge Arnold.
I've also filed 2 pieces of paperwork that petitions the judge to end my requirement to register forever with 2 different agencies.
Okay. You know what?
Public defender.
You're going to talk to Judge Arnold's about that when you go to court on January 20th, okay?
So that's
All right.
income, that's your public defender, and that's the date that you need to be there.
And I would like to say the reason I'm there is because their own laws, their own paperwork says that after 10 years, I have the right to file the paperwork.
You do have the right to petition to deregister. I'm not telling you you do not, okay? But I want you to know that you have to go to courtroom 1H on January 20th. That's all the business we're going to do today is that I'm telling you your next court date, okay?
Is that 8:30 or 1:30, Judge?
1:30.
So I'm gonna write.
I have been declared incompetent by a judge, so I struggle. But I'm just trying to tell you the facts and I'm trying to follow the law.
Thank you, Mr. Knoll. All right, once you get that form from Mr. Castle, you're free to go.
1H, okay? Next Tuesday, 1H downstairs, and Ms. Pinkham can answer any of your questions.
So sorry, so sorry, so sorry. Okay, so I did have, I had 2 short clips for her. I played that one last night, and I was supposed to play the second one today. And it looks like I deleted the wrong one after my stream last night. So you saw that one again? All right, one more clip. Oh man, this gets bad. Oops, I clicked it open on my computer instead of on my stream. I was ready to see it.
Okay, the court is on the record in 3 cases. City of Conneaut versus Sierra Perry, 18 TRD 1583, 18 CRB 442, 18 CRB 413. Just to provide some bit of history here, back on December 16th of 2018, Ms. Perry appeared in this court and pled not guilty to 1 count of unauthorized use of a motor vehicle, a first-degree misdemeanor in the 1583 case. Not guilty to 1 count of falsification, a first-degree misdemeanor, and obstructing official business, a second-degree misdemeanor in the 442 case. and not guilty to possessing drug abuse instruments, a first-degree misdemeanor, and criminal trespass, a fourth-degree misdemeanor in the 413 case. A pretrial conference was scheduled in all of these cases on January 29th of 2019. Ms. Perry failed to appear, and as a result, warrants were issued for her arrest. Ms. Perry was arrested some 7 years later. On these warrants, on January 8th, 2026, she appeared before this court. The court lifted those warrants and set bond in each of these cases. Ms. Perry has been unable to post bond and is appearing at this, what is essentially pretrial conference in all three cases from the Conneaut City Jail. Her attorney, Edith Jonas, is in the courtroom. She's appearing at table 1 on the video. Also in the courtroom is law director John Lewis. So I appreciate both attorneys being personally present today. We weren't able to handle this case yesterday as originally scheduled because of the court schedule, but and I appreciate you being here because of the weather. So the court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. The offer that's been extended to Ms. Perry would be in the 18 CRB 442 case, plead guilty to the falsification charge and dismiss the remaining charge of obstructing official business at her cost. In the 18 TRD 1583 case, plead as charged on the unauthorized use of a motor vehicle. And with pleas in those cases, 18 CRB 413 would be dismissed at Ms. Perry's cost. With regard to the unauthorized use of a motor vehicle, I attempted to contact Mr. Michael Pignati. He's the alleged victim of the unauthorized use charge. I left him a voicemail yesterday afternoon and also left him a voicemail this morning. And he has not replied to either of those voicemails, so I don't really have his input on it. Maybe the fact that he didn't call me back means that he's not interested, because the voicemail message did say this is Michael Pignati, please leave a message, words to that effect. So I kind of take that as he's not really interested in this case from all these years ago. With pleas to the charges that I just mentioned, Your Honor, the state would recommend probation, or the city rather, would recommend probation, whatever fines that court would deem appropriate, along with court costs. Thank you.
Okay, yeah, okay, so we were talking about this, every once in a while we talk about this, that it used to be grand theft auto, it used to be just a big deal. Taking someone's car, when I was growing up, I was told, now remember, this was back when you were just told whatever and you believed it, that if you stole someone's car, it was a minimum of 5 years, minimum. It was just such a big deal. And it came from, if you stole someone's horse, that was a hanging crime. So, that she stole someone's car, he got it back, but she stole someone's car 7 years ago and then was just on the lam for 7 years. And the state just asked for probation for this.
Before we proceed, Mr. Lewis, the vehicle where Mr. Pignati is the alleged victim, the vehicle, was that returned to him? I mean, it wasn't stolen, was it?
He got the vehicle back. Right?
Okay.
Yes.
Just wanted to make sure.
Immediately after it was used by Ms. Perry, basically.
Okay. Ms. Jones?
That is our understanding of the agreement today, sir.
Okay. Okay, so Ms. Perry, it's my understanding today that you wish to enter a guilty plea to the one count of unauthorized use of a motor vehicle, a first-degree misdemeanor in 18 TRD 1583, and to one count of falsification, a first-degree misdemeanor in 18 CRB 442. In exchange for those guilty pleas, the charges of obstructing official business, possession of drug abuse instruments, and criminal trespass. In all of these cases, the remaining charges would be dismissed at your cost. Is that what you would like to see happen today?
Yes, Your Honor.
You understand by pleading guilty to these charges that you are waiving your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving the right to testify or not to testify without any negative connotation. You'd be waiving the right to subpoena witnesses. You'd be waiving your right to a jury trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt. All of those are trial rights you'd be waiving by pleading guilty to these charges. Is that what you wish to do today?
Yes, Your Honor.
You are representing by Ms. Jonas. Have you had sufficient time to consult with her, and are you satisfied with her counsel?
Yes, Your Honor.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, Your Honor.
Are you currently on probation, parole, community control, or post-release control with any court?
No, Your Honor.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty to these two charges today?
No, Your Honor.
And are you thinking clearly and do you understand everything that's happening?
Yes, Your Honor.
Okay, I'm going to ask the corrections officer to provide you two of the Form 3 documents. I'm going to obtain those same documents. So don't sign anything, Ms. Perry, until I've provided these same documents to your attorney and she can advise you further, okay?
Yes, Your Honor.
Those are those forms I was talking about, Sarah, so you can sign them, but it's reiterating your rights that you'd be waiving.
Mm-hmm.
Yeah. And the date is 15/6.
They've been signed and dated.
You say 16?
They're signed.
Okay, thank you. Okay, the court does find that Ms. Perry and her attorney have executed in open court the written waivers. The court does find the defendant's pleas of guilty to charges of unauthorized use of a motor vehicle, a first-degree misdemeanor, and falsification, a first-degree misdemeanor, to be knowing, voluntary, and intelligent. The court will accept the guilty pleas, and I will therefore find her guilty of those offenses. I will dismiss at the defendant's cost the balance of the charges in all three of these cases. Okay, the court will now proceed to sentencing. Ms. Jonas, is there anything
Here we go, guys.
you would like to say in mitigation of sentence?
Yes, so I did have an opportunity to speak with the client, sir. She is a resident of California. She moved approximately about the time these charges came out. I would even question service because I think she moved there shortly thereafter, but it's not, we would waive any defects if they're already. She came here because her 3 children were in the custody of the grandmother, and the grandmother passed away last year. So she came here in November. She did a virtual hearing in July through Ashtabula County Juvenile Court. She did a virtual hearing in July of 25, and they said, we can't do anything until you come here. You haven't visited, you haven't, blah, 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 blah. So she came here around Thanksgiving and has been staying out with a friend at 1219 Mill Road in Pierpont. She's trying to establish visitation at Rooms to Grow, which was ordered. And the next hearing is in March, and she will be staying here at least until March. out of the 3 children, the oldest, the 13-year-old, is the only one that wants to go live with her. So that's the only child that she is currently attempting to get custody of. That's why she came back here. She has housing in California. She has employment in California. It's just this short stay here, and she did it for her child.
This attorney right now is just feeding him bullets for his gun. one after the other, after the other.
Obviously,
Oh, it gets
trying to get
bad.
custody. So she'll be here at least until March. I don't, and hopefully we'll begin visits soon. We would just ask that she be released. She's trying to get temporary employment, and to help pay for her stay and peer upon at her friends, and to do anything CSB requires of her.
Okay. Thank you. Ms. Perry, before I impose sentence, is there anything you would like to say?
No, Your Honor, thank you.
Okay, Mr. Lewis?
Thank you, Your Honor. So the incident involving the falsification and the unauthorized use of a motor vehicle happened on December 18th, 2018. Units were dispatched to 904 Broad Street here in town. Mr. Pignotti
Share no
went
boobies.
in his
Sounds
truck,
like
went to a
share no boobies, and we don't agree with that. So we're gonna have to nix that word.
an apartment there, arrived at the rental apartments, and he was attempting to speak to a tenant, one of his tenants. While he was knocking on the front door, a woman unknown to him, dressed in jeans and a hoodie, exited through the side apartment window. She jumped into Mr. Pignotti's truck, which was still running, and drove off in the truck. Went around back behind the apartment complex where she failed to make the turn to exit, and went over a railroad tie and then into a side yard, almost striking a wooden fence. The woman's description was given to law enforcement. She eventually was cited by then Detective Sullivan on Orange Street. She matched the description given. She identified herself to law enforcement as someone other than Sierra Perry, and officers, through further investigation, were able to match. One of the officers thought that they knew who she was, actually was, and they did a search on her BMV photo, which was a match, and she was placed under arrest at that time for falsification. In the report, Your Honor, it reads that Mr. Pignotti's truck did not seem to be damaged, at least any visible damage to the truck. And after she was apprehended, she was obviously taken into custody. Thank you.
Thank you. Any response to that, Ms. Jones?
I think so.
Okay, Ms. Perry, you've got a substantial criminal record. So, officer, is there a holder on her?
No.
Her CCH indicates there's a warrant out of Austintown, Ohio. But Ms. Perry, are you actually in Ohio because you were charged with grand theft in November of 2025 in California?
Say that again?
You were charged with grand theft at California. Are you aware that you have charges of grand theft November 15th of 2025 in California, specifically Capdorville?
I have no idea about that.
Yeah.
What is it?
You also have, there's indications that you violated your parole. Are you on parole in California?
No, I completed parole.
When did you complete it?
In October.
What were you on parole for?
A gun and burglary.
you expect me to believe, and I understand that's what you explained to your attorney, but you expect me to believe that you're actually going to get custody of a child with your criminal history?
All the other people who are in prison or locked up that have a chance that want her.
Yeah, what about you, though? You have charges of grand theft pending in California. She's given the maximum jail sentence. I'm giving her the maximum jail sentence, 180 days on the unauthorized use of a motor vehicle on 18 TRD 1583. And I will run consecutive the maximum jail sentence on the falsification, 180 days in 18 CRB 442. I will give her jail credit of 7 days, that being from the date of her arrest of January 8th, 2026 to today's date. These are county commitments, and her record is deplorable. I mean, absolutely deplorable. And to think she can get away with what she did 7 years ago and then all of a sudden appear in Asheville County and thinking that she's just can serve a 7-day jail sentence, be released, is ludicrous. Because you have been on a crime spree ever since you left Ohio in 2018. I mean, there's all kinds of stuff you've been doing, and they're crimes of violence and crimes of dishonesty. So you're not being honest with us today. You are given the maximum jail sentence. You do have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have a right to have a notice of appeal timely filed on your behalf. And you have a right to have documents provided to you necessary to file an appeal on your own behalf. I'm not imposing fine. I will order all court costs to be paid in 1 year. Anything further, Mr. Lewis?
No, Your Honor.
Ms. Jonas?
Nothing, sir.
Thank you very much. This matter is concluded. Thank you.
The state asked for probation and he just gave her 380 days. He didn't shout this time. Instead, he just destroyed her with quiet words. Oh my gosh, I can't believe he did that. I cannot. All right, guys. Thank you so much for coming out today. I appreciate it. I really, really do. I'm going to start OJ. It's a little early, but I'm still going to start OJ. Maybe I'll play it a little long today. All right. Please behave today. All right. I want to see you tomorrow morning. Get some rest, guys. Actually, it's Monday. Get to work. Get to work. Thanks for coming out. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.